If your lordship
Why
sees
was
both
it
these
that
articles,
post 1957,
yes,
post 1957, neither the government or the legislative assembly of Jammu and Kashmir, nor for that matter the political establishment in the rest of the country represented by Parliament, nobody ever thought of amending the Indian Constitution to bring the Jammu and Kashmir Constitution expressly within the fold of the Indian Constitution.
the 370.
And this second aspect, Mr. Subramaniam, which I thought I'll just place at this stage, I didn't want to place it right at the stroke of lunch, which was while our Constitution does speak about the Constituent Assembly of the state of Jammu and Kashmir, which was then in contemplation at the date of our Constitution on 26th of January 1950. Significantly, after 26th of January 1957, our Constitution does not speak of the Constitution of Jammu and Kashmir at all.
Milord, I'll say, Milord, with great respect. The reason being that the Constitution of Jammu and Kashmir, Milord, was a product which was envisaged because there was a Constituent Assembly. But the way it has happened is the Constitution of India, Milord, the applicable provisions were brought into the J&K Constitution. And the J&K Constitution, Milord, had its own chapters, which I have pointed out for your Lordship's consideration,
Therefore,
establishing its framework.
Our Constitution speaks of only one institution, namely the Constitution of India, and the Constitution of India as it applies to the state of Jammu and Kashmir, subject to modifications and exceptions.
That's right, my Lord.
Therefore, the only document, the only compact, or the only basic document that is within the contemplation of our Constitution is this Constitution itself.
I agree. But, my Lord, now the question is, was J&K Constituent Assembly not tasked with a framing of a constitution? That is clear from sub-article 2 of 370. Under 372 and 3, my Lord, if your Lordship sees both these articles...
Post 1957,
yes.
Post 1957, neither the government or the legislative assembly of Jammu and Kashmir, nor for that matter the political establishment in the rest of the country represented by Parliament, nobody ever thought of amending the Indian Constitution to bring the Jammu and Kashmir Constitution expressly within the fold of the Indian Constitution.
My Lord, it may not be necessary. I'll tell your Lordships why, if I can, my Lord, if I may humbly urge, for your Lordship's consideration. The Constitution for Jammu and Kashmir is intended to be applicable to the state of Jammu and Kashmir. But it is a constitution because it is framed by a Constituent Assembly.
But
Lord, there could be...
the Constitution of Jammu and Kashmir imposes limitations on the power, on the executive power of the Union and on the legislative power of an organ of the Union, namely Parliament.
The Constitution of J&K doesn't impose any fetter.
The Constitution of J&K refers to the fact that, the residuary power would be vested with the...
Yes. Just forgive me. I'm obliged.
That is a clear fetter. I'm just giving you one example of the fetters. But therefore, there are fetters in the J&K Constitution on the operation of the Union Constitution.
Well, this is actually the asymmetry.
It was not necessary after 1957 for the Constitution of the Union, which was now the only constitution for the entirety of the country, including Jammu and Kashmir, which had acceded to India. Was it not necessary for the Indian Constitution to be amended to recognize some other constitution as an intrinsic part of this Constitution?